Thanks, Sam, and welcome, everyone. Today we're going to be talking about some of the more complicated issues in the deposit side of the financial institution. And I just want to remind everyone, it's always good to take that 1-minute reminder that as we look at these things like power of attorneys and trust and guardianships and estates and all these kind of complicated legal issues, you always have to know what's my side of the fence, meaning when do I need to pick up the phone and call my legal counsel and when don't I? And one of the things that I think we get into sometimes as we get to working with documentation and procedures for financial institutions is to make sure that we stay out of the practice of law unless we have the license to do so. And so it's always a good reminder as we start to look at these documents that if you are running the deposit ops side of the financial institution and maybe you're not a attorney, then of course you want to use your attorney when you need to do so. So I thought we'd start today with power of attorneys. I guess we should list these maybe in the order today of the ones we lose money on, and this is probably the top one in the country. And talking about power of attorney documents, and of course the person acting for the power of attorney, who is an attorney in fact or an agent or convenience signer. There's lots of different ways that we call them around the country. So a power of attorney, the ones that we deal with primarily, you are going to see agents, convenience signers, or authorized signers, and these are sort of baby power of attorneys created on the signature card. One of the areas that I always see where people have problems with this is that they line through this, or if it says authorized signer only on individual accounts, or if it says agents, can they be on joint accounts, can they be on individual accounts, to make sure that you actually follow your signature card and card agreement on these small baby type documents, because it is created on the signature card usually by a paragraph, and usually they can only make transactions for the owners. Then some financial institutions in some states can use an in-house power of attorney, and that's provided by the financial institution. It's a little broader than the agency documentation or the authorized signer on the signature card. It's usually attached to the signature card, put with the signature card. Usually your agent or your attorney, in fact, can act on more than one account then, but still very limited, and they revoke it right in front of you. And I guess the big gun here is these out-of-house power of attorneys drawn up by customers' attorneys. And remember, customer attorneys are always there to protect the customer. These documents are provided by our customer, and then, of course, a lot of times they can be revoked in many ways in different states, sometimes just by walking out the door and going, I revoke. So one of the things that we always have to be careful about these outside documents is, do we have a process for legal counsel to review them? So the baby ones, the agents, the convenience signers, and the authorized signers, again, only making transactions for the owner. Typically, they sign on one account. They can't change ownership or do anything to benefit themselves, such as cashing a check made payable to the authorized signer against the account. And in some cards, we only allow one, and only on individual accounts. So I've seen institutions where they make mistakes with these, where they'll say, well, we didn't like the word agent, so we lined it out and put authorized signer. Now, really, it's important to follow your signature card as it spells it out for you on your documentation. Sometimes they don't allow for an agent or an authorized signer on a joint account or a multiple party account. So you want to make sure that it is clear when agents can go on and what kind of accounts that they can go on, or authorized signers. And some states call these convenience signers. They cease at the death of the owner. They typically only appear in the system, in your systems, as a memo, and they don't usually appear on the face of the check. And sometimes in some states you will see the language of, is it durable or not durable, meaning does it go on past incapacity. So a lot of times these simple ones are just revoked by signing a new signature card contract, taking off that agent or that authorized signer. So it might look like you want to pull your state law and take a look at it. Here's the particular state. I just pulled it, and you can see it's called a convenience account here. And it says the parties to the account own the account, and one or more convenience signers may make transactions for a party. And it says that the convenience signer doesn't own the account. So these are the things you want to go in and look at your state law and see, what is it called in my state law, if it addresses it at all? Is it a convenience account, or is it an agent? And here's one, that designation of agent. By signing a writing, you can designate one or more persons other than the party as their agent on the account. And so again, talking about termination at death, and that's what the state law says. If you're in a state like mine in Louisiana, we do not have actually a law on agents other than our power of attorney statute. So then what the agent on the deposit relationship can or cannot do is determined strictly by the signature card contract. So then that becomes even more important. The option of an in-bank power of attorney, which some use and some don't, depending on your state law, of course, because if you're in a state that has particularly strict laws about the format that it must take and how it has to be handled, typically you won't do an in-house power of attorney. But it's a document that attaches to the signature card. Typically, we only allow one power of attorney on more than one deposit account, although I've seen that. I've seen them try to put all their kids on there, and that's something your financial institution can make some procedures about. So whether or not you allow more than one power of attorney document or attorney in fact on an account typically ceases at death. I like the in-bank documents. They work in a lot of states. They're a little broader than that authorized signer agent, and probably not as broad. It's kind of like Goldilocks, you know, one's too hot, one's too cold, but maybe this one is just right. These outside legal documents, however, sometimes you'll have a state law like in Illinois or Georgia where they actually dictate the format of the document, or Texas. So they come in all shapes and sizes in many states, but in some states they have to follow particular format. I think the major losses on these have come in the area of when we let the attorney, in fact, act outside their scope. You know, a good title to a workshop would probably be 615,000 reasons why you don't want to accept outside power of attorney documents. But the last lawsuit was from Illinois that I saw, and it was involving where a nephew had taken off the niece as a POD. He had the aunt's power of attorney, and he had taken off the niece and put himself as the POD beneficiary on the account. And you can see there that he's not acting on behalf of the person that he's been named by, the grantor. He's acting on his own behalf. And so that's where you have to really weigh this. Are we going to allow these folks to change legal ownership to benefit themselves? Are we going to allow them to put themselves as pay on deaths or in trust for? And when they start doing stuff like that, is it outside the scope of the document? And is it happening out there in your branches and you don't even know? You know, somebody walking in with a document to a teller or to a new account rep, and they're just changing things on the system with this document, and you don't even have a procedure to say what to do. So I would really encourage you. It's not that we don't want to take these documents from time to time. It just is that we ought to have some pretty stringent procedures about the way that we take them, and that somebody is actually looking at them to determine whether our financial institution wants to be engaged with this document, this power of attorney. Now, again, in some states, if they follow particular formats, you guys have to take them. But in other states, you don't have to take them. You have the right to read and review, and that should be stated in your signature card contract. So you want to make sure you've got that wording if you can. Some of the harder things with these, and there's quite a bit of hard things, they want to put them on business accounts. Not on business accounts. They want to put them on trust. Well, again, we'll talk more about that, but when we get to trust accounts. But I will say this, it's very rare that you see a trust that will let them name an agent. And so, again, these living trusts aren't written that way. Now, I saw one the other day for a business account that was set up for an employee, and there was the ability to name an agent. But for the most part, you're not going to see that built into a lot of these documents as we go through. So one of the things that I get asked a lot is about CIP with power of attorney documents, like who's the customer? And it tells us in a frequently asked question from FinCEN, the CIP rule provides that a customer generally is a person that opens a new account. So when an account is opened by an individual as power of attorney for a competent person, the individual with the power of attorney is merely an agent acting on behalf of the person with that account. Therefore, the customer will be named owner of the account rather than the individual with power of attorney. And by contrast, an individual with the power of attorney will be the customer if the account is open for a person that lacks legal capacity, such as under a durable power of attorney. So who the customer is has to do with whether or not they're competent or not, which gets to be another whole game here about determining that. A lot of times financial